think I'm able to answer your lordship right away because I don't have that information. Now, my lord, now your lordship may kindly see, my lord, on 14.3 when the government says stop it, then kindly see, my lord, on seal number 27. The one other aspect, my lord, which may require your lordship's consideration is what is mentioned at seal number 26.
Yes, sir.
Government of Karnataka cancelled the resolution dated 14/9/2020. We are not able to lay our hands on this resolution. So I am afraid, my lord, I am not able to assist your lordships as to what is the cancellation that was done, which is available at page 281.
So what is that resolution 2020, 14/9/2020?
My lord, I'm not able to help your lordships on that, my lord. That's fine.
All right. Yes.
My lord, what that I'm given to understand.
Page 282.
No, that is all right. That, my lord, is, if your lordship will kindly see 2710, that may show some light on what is this. Give me that. This one, page 281. My lord, kindly see page 281, my lord. It seems to throw some light as to what is this.
282.
Yes, correct, my lord, 282. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ದಿನಾಂಕ so and so
282.
Yeah, ಪರಿಹಾರ ನೀಡದೆ ಜಮೀನನ್ನು ಉಪಯೋಗಿಸಿದ
50/50 scheme was withdrawn.
Scheme has been withdrawn. ರದ್ದುಪಡಿಸಲಾಗಿದೆ.
Cancelled. Withdrawn.
So, and then, my lord, there is so much of maladministration in Muda that the government, my lord, had appointed a committee and kindly see, my lord, serial number 27.
For what purpose?
To inquire generally into what all is happening in Muda.
That is nothing. There's no bearing on this.
I also see that, my lord, because there is no specific point on which they were asked. But the fact appears to be that
General maladministration.
that is a general. I agree. And then, my lord, there is a show cause notice issued. Now, my lord, seal number 28. A show cause notice issued to the deputy commissioner calling upon Muda to answer the allegations made, which your lordship will find, my lord, at page 292.
All right. Yes.
(292), my lord, there are, again, my lord, if your lordships ask me a question as to whether this has anything specific in relation to the allotment made in favor of the petitioner's wife, the answer to that question is no. There is nothing specific.
No, that has nothing to do. Yeah, general maladministration.
General maladministration.
That is in public domain.
Yes, my lord.
Yes.
Maladministration is in public domain.
No, true. That's public domain. That maladministration is more in Muda. That's a different thing. Yes.
And then, my lord, your lordship may kindly turn to 29. 9/11/2023, Deputy Commissioner called upon Muda to stop all allotment of sites. And then, my lord, allegation, etc. And then, my lord, 3/7/2024, there was a complaint filed by respondent number 4 before the jurisdictional police, which if you brought your lordship's notice, my lord, the magistrate said, how can I proceed afterwards?
No, that's not that.
This is the complaint filed with the police.
Complaint before jurisdictional.
Yes, correct. Yes, correct.
Then local.
No, then, my lord, we have another, that we have, my lord.
First jurisdictional police,
court.
then local,
And
then
my lord,
private
seal
company.
number 36.
Yes.
Seal number 36.
That's what Rangnath Reddy told.
Yes, yes,
They've
correct.
complied with all 154,
Yes, yes,
1,
all that has been
and then
done.
200.
All that has been done, my lord, we have set it out. And we also filed a complaint under 200 before the magistrate. Of course, my lord, it was reserved for orders on the question. Special court, I'm sorry. On the question as to whether the governor's sanction was required even to proceed further. It was posted for orders on that question.
It was
When
reserved.
your lordship,
It was reserved for orders. Now it is preserved for orders.
it is preserved for orders.
Because of these.
Yeah, your lordship protection.
Yes.
So, my lord, what was reserved for orders was
Is now
preserved for your lordship protection.
Yes.
That is how it is.
Document for Taripura, page 320. Go to the police station.
Yeah, that's okay. Now, my lord, let me go to the order passed by the government at page number 42. Kindly see the order. Now that your lordships have got, these are the factual aspects which I wanted to highlight for your lordships, from which my respectful submission to your lordship is that the connection between the petitioner and the actions which were taken in 2017, which culminated ultimately, my lord, in the execution of the sale deeds in 2022, is quite clear and undisputable. Therefore, my lord, it is not, the question I would pose for myself is whether in 2022 the petitioners had any role. That's not the correct question. It might respect to submission. The correct question will be in 2017. Did the petitioner have a role to play? Undisputedly, yes. And I think, my lord, he was also the district minister. He was also the district in charge.
He was chief minister, sir.
Yes. No, he was deputy chief minister.
ಯಾವಾಗ?
2017.
17. Chief.
17, he was chief minister.
Yes. Where
Yes.
is district in charge?
No, I'm sorry. When 2004, he was district in charge. 2017, he was the chief minister. He was chief minister for 5 years, full term.
All right. Yes.
Yes. No, my lord, that's right. Now, my lord, please look at page 42. The petition, my lord, I want to draw your lordship's consideration.
Governor's order.
Governor's order.
Hmm.
Now, my lord, what was told to your lordship was that there is non-application of mind by the government with respect to the question as to whether there is a case for inquiry or not.
That the learned Solicitor General is elaborately.
Yes, I want to point out one thing to your lordships in that. If it has already been pointed out, then, my lord, I apologize for the repetition.
No, I don't
But
know.
unless I tell your lordships what I am saying,
know
you
what
can't
you're
say
pointing
everybody.
at.
Exactly, my lord. Therefore, that is the reason. I know, my lord, it is a difficult question. Unless I say,
Yes.
you will not be able to say it's already been said. So let me say what I want to say.
So after it is said, I will.
No, of course, your lord. My lord, I recognize, my lord, the court's authority, and the court should stop a counsel if there is repetition. Of course, my lord. Otherwise, this will go. This will be ad nauseum. My lord, kindly now see, my lord, the paragraph number 4 at page 43. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri Venkatachalapati IAS was constituted to look into the present matter. However, the government, upon considering the facts of the present matter as reported in the media newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member inquiry committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land, and irregularities in allocation of land. Further, the constituting of a committee under the IAS officer and immediately constituting one more committee under a retired judge of the High Court, and the government's own acceptance that there is a potential big-ticket scam in the allotment of sites by Muda does not inspire much confidence. It is well-settled legal principle that persons against whom allegations are made should not be empowered to decide the course of action, even after such grave allegations being involved in the present case, and the fact that the materials prima facie supports the allegation, therefore decision taken by the council of it is irrational. That is, my lord.
Now I can say it is already said.
Yes. Now, my lord, please look at paragraph number 6.
Hmm.
I have considered the decision of the cabinet dated 1/8/2024. I am going to skip that because it's already been said.
Yes.
Madhya Pradesh, etc., already been
Ella.
said. So I am going to skip that. Now, my lord, please be kind enough to turn to paragraph number 10. That, my lord, is the point that I want to emphasize for your lordship's consideration. Upon perusal of the petition, along with the materials in support of the allegations in the petition, and subsequent reply of Sri Siddaramaiah and the advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. Therefore, my lord, I pause for a moment here to say, the governor, my lord, has said, look, there is one thing that is being said by one set of people. There is another thing that has been said by another. Here is the cabinet which says nothing is wrong. Here is somebody else who says something is wrong. There are two versions. Therefore, I will get it inquired into. And it is very necessary that a neutral, objective and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of the offence. So therefore, my lord, this much of application of mind, in my respectful submission, is more than ample. Anything more, there would have been, my lord, an allegation that the
You're
government
reading
has...
the order.
My lord?
You're reading the order.
Yes.
The learned Solicitor General has produced the entire file.
No, my lord, I know, I'm aware of that.
So there is more than. what
More
is
than
there.
that. I'm not going into that, my lord. Your lordships are going to look at it. My learned friends are
So
going to.
the submission of not even a semblance traveled to abundance after the original file was placed.
Yeah, absolutely, my lord, absolutely. And I would say, my lord, the original file discloses much more than what the order discloses. Even on the order, it cannot be said that there is non-application of mind. In fact, if anything more had been said in the order, my lord. Now, my lord, lot of material is there available in the file. Whatever is available, my lord, your lordships are
We'll
going to get it.
consider, yes.
I'm not going to comment on that. Now, take the order on the face of it.
It does bear application of
It
mind.
does bear application of mind because if anything more had been said in the order, allegation would have been that you have made up your mind on one way or the other.
He is not,
No, no.
authority to make up the mind.
Allegation. I'm underlying the word allegation. Is that you would have done it. My lord, you do, you are damned. You don't, you are damned. My lord, this is a very thin line to be drawn. Where is consideration? Where is non-consideration? Now, my lord, this is what I wanted to point out. Now, my lord, what was told to your lordship was, how is it that the petition that has been filed, my lord, we produced for your lordship's consideration the petition that we had filed with the governor of 31/7/2024.
Yes, you told. A
I produced-
memo
yes,
jate ಕೊಟ್ಟಿದ್ದಾರೆ.
exactly.
ಹಾ.
And I'm sure, my lord, your lordships will look at the records to find out as to whether it is there or not, because insinuations were made.
Which file? Which file it is not there? You've seen. All right.
Sir, is it there or not?
I will also see.
The reference to it, it means the reference to it, we have also not.
We have no, I have had no access, but
Yes, yes.
anyway, your lordship will look at it, my lord, whether what I say or what
The
he says.
file is given to me.
Your lordship look at it, my lord. Now, my lord, the allegations in the 31/7/2024 communication is identical to the allegation that have been made in the complaint of Mr. T.J. Abraham. Now, my lord, in a situation of this kind, what was told to your lordship was, I was given a copy only of T.J. Abraham's petition. I was never given a copy of the petition filed by respondent number 4, and therefore, the order is vitiated. My lord, and it was made to appear that as if permission is granted to the respondents by this order. Kindly see, my lord, what para 11 says. I think it's a complete misreading of the order of the Honorable Governor by the other side.
Clarified.
My lord, I'll clarify it, my lord.
That is clarified.
I didn't follow.
That is clarified by the Solicitor General.
Very well. If it's been done with it is not a question of anybody being given permission to do anything. It is lifting of a bar. Now, my lord, in this context, if I am right in my submission with respect to paragraph number 11, which has been clarified to your lordships, now, my lord, there's one submission that I want to make. My lord, your lordship may kindly look at one judgment of the Honorable Supreme Court, my lord. There are three distinct concepts. One is a direction, the other is sanction, the third is approval. This is the pyramid. In respect of each of these actions, the standard required is different. Now, my lord, that has been laid down by the Honorable Supreme Court, my lord. In 1952 to SCC 203. 1952, volume 2, SCC 203. Give it to me. One ನಿಮಿಷ.
SCR.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ ಇಲ್ಲಿ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ಪೇಜ್ 760.
Now they have done it.
ಮಾಡಿದ್ದಾರೆ ಅದೇ
ಈಗ ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ
Right from 50 it is.
ಮಾಡಿದ್ದಾರೆ ಈಗ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Earlier from 50 to 69 it was SCR. Now it
ಎಲ್ಲ
is.
ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ಪೇಜ್ 762 in volume 2. Well, kindly turn to paragraph number 11 and para 12. My lord, we are not, in the instant case, my lord, we are not concerned with either direction or sanction. We are only concerned with approval.
Yes.
My lord, kindly see para 11. In both the cases of sanction and direction, An application of mind is necessary. But there is an essential difference that in the one case, there is a legal impediment to the prosecution if there be no sanction. And in other case, there is a positive order that the prosecution should be launched. For a sanction, all that is necessary for the one to be satisfied about is the existence of a prima facie case. In the case of direction, a further element that the accused deserves to be prosecuted is involved. Therefore, my lord, direction is at a higher pedestal, then your lordships have sanction, and then your lordships have the concept of approval.
Last 4 lines of that paragraph.
Yes, my lord. Whether sanction should be granted or not may conceivably depend upon consideration extraneous to the merits of the case. But where the prosecution is directed, it means that the authority who gives the direction is satisfied in his own mind that the case must be initiated. Sanction is in the nature of a permission, while a direction is in the nature of a command.
So-
Now, my lord, where does this come? This is neither a sanction, neither a direction, it is an approval.
Because
It is at the bottom of the pyramid. So therefore, if direction requires something more, it requires the highest element of application of mind, and then your lordships have the sanction and then approval. So, my lord, if we look at it that way, then, my lord, the standard required for the purpose of 17A is much less in rigor than for a sanction under 19. Now, my lord, please see para 12. Let us now examine some of the decisions on the subject. For the appellant, strong reliance was placed on the judgment of the Privy Council in so and so, and it was argued that on the basis of some of the observations of the Judicial Committee that a sanction was an important and substantial matter and not a mere formality. The facts in that case were that while there was a sanction of the government for prosecution under the Cotton, Cloth and Yarn Control Order, there was nothing in the sanction itself or in the shape of extraneous evidence to show that sanction was accorded after the relevant facts were placed before the sanctioning authority. To quote the lordship's own words, there is no evidence to show that the report of the sub-inspector to the district superintendent of police, etc. I'm going to skip that. Prosecution was in a position either to produce or to account for the absence of the report made to the district superintendent of police and the endorsement of the district magistrate referred to in the sanction. It is in this connection that their lordships emphasize that sanction to prosecute is an important step constituting a condition precedent and observe, looked at as a matter of substance, it is plain that the government cannot adequately discharge the obligation of deciding whether to give or withhold a sanction without a knowledge of the facts of the case. Nor in the lordship's view is a sanction given without reference to the facts constituting the offence a compliance with the actual terms of clause 23. This, however, is no authority for the position that a sanction stands on the same footing as a direction. Therefore, sanction is different from direction. It is true that the facts should be known to the sanctioning authority, but it is not at all necessary that the authority should embark also on an investigation of the facts, deep or perfunctory, before according sanction. Your lordship may mark that one out. Even a deep or a perfunctory, he need not do it. The decision lends no support to the view that wherever there is a sanction, the sanctioning authority is disabled under section 556 of the code from trying the case initiated as a result of the sanction. On the other hand, there is plenty of support for the opposite view.
Yes.
Now, my lord, having shown to your lordship this, may I now request your lordship to take my compilation of judgments, my lord. I'm not going to show to your lordships, take your lordship through all this, because in our submission that we have made, we have extracted the relevant paragraphs, my lord. Though, I must tell your lordships, my lord, that it appears, my lord, that the government in England appointed a commission to go into the merits and demerits of oral arguments in courts and written argument that is prevails, my lord, in the United States. And the report of the commission was a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written arguments.
Yes, sir.
But, I know, but
All right. Yes.
I'll leave it. I have given your lordships the extracts of the paragraphs, which, my lord, will not have
We'll harmonize the two.
harmonize the two, and your lordships may read that, my lord. But having said that, I want to point out your lordships one thing. Now, my lord, kindly look at the scope of 17A, which your lordships have looked at in several cases. Well, your lordships have seen Ashok's case, which is your lordship's judgment. I'm not going to detain your lordships on that. But then, my lord, before the judgment in Ashok came, There was another judgment of your lordships in Sri Rupa,
Yes.
which, my lord, your lordship will find is at page 496,
Hmm.
which is in volume 2.
Hmm.
Please look at it for a minute. I'm just going to show to your lordships for a different purpose. I know, my lord, your lordships have authored the judgment.
Yes.
Kindly see paragraph number 11. What was it? What was the aspect which prevailed upon this honorable court to hold, my lord, that the sanction was not, that the sanction was not enough?
Approval.
No, it just said ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ ಅಷ್ಟೇ.
ಅದಕ್ಕೋಸ್ಕರ ಬರೆದಿದ್ದು.
ಅದಕ್ಕೋಸ್ಕರ, exactly. Now, this aspect of the matter, I only wanted to point out, your lordship, that particular fact which your lordships are now seeing. This aspect of the matter, my lord, was looked at again by another coordinate bench of this court.
Yes, when it came again,
Yes.
there it is held that it stands on a different footing.
Yes.
Because it was 19 then.
No.
It is not 19,
No,
is it?
ಅದು 17 ಏನೆ.
ಮತ್ತೆ?
ಹೌದು. ಇಲ್ಲ, ತಾವು ಕಳ್ಸಿದ ಮೇಲೆ ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಓ, ತಿರ್ಗಾ
your lordship may look at that, my lord, which is at page 510.
Volume.
My lord, that is the judgment of his lordship Justice Sanjay Gowda.
Yes.
Please be kind enough to turn, my lord. There your lordship may kindly see, my lord, how it has been distinguished. And that is why, my lord, my respectful submission to your lordship will be, do not apply the approach that your lordship adopted in Ashok's case. My lord, please be kind enough to turn.
Para 29 to 31.
My lord, please see para 33, my lord. I want your
33 is the
lordship to
finding.
33.
But 31 is what is said.
My lord, what is relevant in order actually is para 39 to 49.
All right.
But please see para 33 for a minute.
Yes, sir.
At page 516. Section 17A of the Act is drafted with the overarching objective of ensuring that unnecessary investigations against public servants are prevented, and the state government is required to take a decision to accord or refuse approval to conduct an investigation within a time frame. This indicates the balance that the law intended to strike in the manner of an investigation being conducted against a public servant. Now, my lord, please be kind enough to turn to paragraph number 36. I'm going to skip 34 and 35. At this stage, the stark and striking difference.
No, there it was again elaborate. That's why 49, my order is quoted. 51, it is said it bears application of mine, dismissed.
In fact, your lordship's order is quoted, and, my lord, the learned judge holds because of that ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ was the only ground. But then, my lord, the law is explained further. Now, my lord, just look at para 40. I'm going to skip a few paragraphs, my lord, though I thought it's relevant, but summary is there. To summarize, the law has conferred a twofold protection vis-a-vis a public servant for offences under the Act. The first layer of protection is even before an investigation is conducted, where a prior approval is needed under Section 17A of the Act. The second layer of protection is after completion of investigation, where sanction to prosecute the public servant is required under Section 19. It is clear from the statutory framework the legislature has decided to not only protect public servants from unwanted investigation, but also from a prosecution by making it mandatory for the investigating officer to obtain two different and separate approvals for investigation and for prosecution. It should also not be forgotten that merely because an approval is accorded to conduct an investigation, investigating officer cannot proceed to prosecute the public servant, and he is still required to obtain prior sanction of the government to prosecute the public servant under Section 19. Then, my lord, your lordship may kindly turn to paragraph number 47.
Caesar's wife
My lord,
must be above suspicion.
yes. And now, my lord, no, my lord, that's after those few lines. The integrity of a public servant is required to be beyond suspicion, as in the proverbial adage, a Caesar's wife must be above suspicion. If there exists even a shadow of doubt on the integrity of the public servant, it will not only harm his reputation, but will also tarnish the entire system of which he is a part. Thus, in such a situation, if the aspersions cast on the integrity of a public servant and an investigating officer under the Act harbors a view that an investigation is necessary, it would be in the interest of both the government and the public servant that such a nagging suspicion is obliterated. So, my lord, the word emphasizes nagging suspicion. Is it there or not in this case? That's all the inquiry. Some element of discomfort is enough. Unless you're not with that, nothing. I'm so comfortable with what's happened.
Lurking suspicion.
Lurking suspicion is a nagging suspicion.
Nagging.
Anyway, my lord, that's the wording that his lordship has used now. In order to achieve this objective, therefore, the government should be given the greatest degree of latitude to accord approval for conducting investigation. So this is the approach, my lord. This is what I mentioned to your lordship at the beginning of my submission. Approach must be, if there is some suspicion, allow the investigation to take place. Do not scuttle it at the very start. Then, my lord, the contention, therefore, that the material furnished by the investigating officer is required to be subjected to a microscopic examination before according approval to investigate a public servant, as suggested by learned senior counsel appearing for the petitioner, does not merit acceptance. As stated earlier, before seeking approval under 17A of the Act, the investigating officer would only have to form a tentative opinion to determine as to whether investigation is warranted or not, having regard to the material credible information in his possession at that point of time. It may so happen that after conducting an investigation, investigating officer may very well come to the conclusion that there is no justification for initiating prosecution and may drop such proceeding against the public servant. Thus, the mere grant of approval to conduct investigation would not lead to an inference that the investigation would necessarily culminate in a prosecution against the public servant. And then, my lord, the judgment of this honorable court in Ashok's case is cited. This earlier Sri Rupa's case. The argument that the materials collected have to be considered meticulously, as indicated by this court in WP number so and so, cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case, where the order of approval merely stated that the government had meticulously considered the matter by use of the term Kulankashavagi Parisharagi. The relevant portion of the order reads as follows, my lord. Then, my lord, paragraph 52. In my view, this indicates that the state has applied its mind to the request made by the investigating officer and has considered the matter rationally before according its approval to investigate the petitioner and another. In the light of the distinguishing feature, the decision relied upon the learned counsel for the petitioner in WP number so and so in support that cannot be of any.
So, governor has applied his mind. in
My
this.
lord?
You want to,
Yes.
you
this
want
is
to paraphrase that, yes.
Yes, my lord. This is-
Governor has applied
Yes,
his mind.
correct. Yeah, absolutely, my lord. That's and I want to show to your lord. I wanted to show to your lordship, which I believe I have done, to say what was the basis on which your lordship's judgment in that
No,
case
that
was
Sirup,
made.
I am aware.
That's all. That's all. And I wanted to show to your lordship that this is the, and there's another view that has been taken by this honorable court, another coordinate bench. Your lordship may kindly see, my lord, though it arises under 156.3. Please see, my lord, page 522. My lord, kindly turn to paragraph number 48 at 536.
Yes, this I have.
Yes. But these judgments support the proposition that I am placing for your lordship's consideration, that it should be looked at in a very broad manner, especially having regard to those words relatable to and not commission of or recommendation by. Those words are not there. It is relatable to. In the context of a contractual clause, the Honorable Supreme Court has held, my lord, that these words relating to, in regard to, in relation to, are words of widest amplitude. General Electric. Though, my lord, it arose in the context of the interpretation of a contractual clause, I would say, my lord, the same principle applies when your lordships are interpreting this. My lord, please be kind enough to turn to paragraph 25 of the judgment of the Honorable Supreme Court, my lord, in Renu Sagar.
You want term relatable.
Yes. What is the meaning of these words relatable? How do you understand it? What is so special in law when you use this word relatable?
Paragraph.
My lord, paragraph 25.
It's not part of compilation.
Avaru kottidira copy?
Yes.
Four propositions emerge very clearly from the authorities discussed above. One, whether a given dispute inclusive of the arbitrator's jurisdiction within the scope of the purview of an arbitration clause or not primarily depends upon the terms of the clause itself is a question of what the parties intend to provide and what language they employ. Two, expressions such as arising out of, or in respect of, or in connection with, or in relation to, or in consequence of, or concerning, or relating to the contract are of widest amplitude and content and include even questions as to the existence, validity, and scope of the arbitration agreement. Now, my lord, I'm only the first portion of it. It is of widest amplitude. Otherwise, my lord, I ask myself the question, why did the legislature use the word relatable to? They could simply have used, without that word, the section could have made sense. It is, did you play a role in relation to that recommendation or decision? Is a question. And the role could be minuscule. Even then, the act applies.
Needle of suspicion.
Needle of suspicion. Needle of suspicion, my lord, is the crux of the matter, is what I would submit your lordship for consideration. Now, my lord, another aspect, my lord, I want to take your lordship through the index, my lord, so your lordships get an idea as to what is this, what is it that we are, and if there is any particular aspect on which, my lord, I think is necessary, and if your lordship permit me for me to dilate, I will do it.
163, the Solicitor General has relied on, same judgments.
My lord, yes, and I want to point out only one thing, my lord. In what was told to your lordship by the petitioner was that the law laid down in MP special police establishment case has been watered down.
No, that is clarified.
So therefore, I will not. Very well. But that's why, my lord,
Nawab Rabia went on a different footing.
No, in fact, Nawab Arabia says that's affirms it. On the contrary, my lord, without diluting. What was told to your lordships by the petitioners was that the judgment of the Supreme Court in Nawab Arabia has diluted the law laid down in MP.
No, that submission was diluted.
I will not object.
Yes.
Now, my lord, your lordships may kindly look at. There is one judgment, my lord, which possibly will have a bearing to a certain extent at the present stage
On what?
on discretionary powers of the government. And then your lordship gets Antules's case, my lord. Antules's case, my lord, seems to suggest that the power of the court under 156(3) is not trampled by 17A. Though 17A was not there at
17
that
was
time.
not there.
I done that, and I am aware.
5A of the old act.
The old provision, my lord, they were considering that. 17A was not there. 17A
No,
was
17 is 2018.
It-
What was considered was not even section 19.
No.
It was under the old
the
act.
old act, 5A.
What was sanctioned in,
5A.
that is Abdul Rahman and
5A,
case.
5A.
Yes.
So even there, the question, my lord, is as to whether the power of the court under 156(3) is circumscribed by the requirement of a permission. And the view, as I understand in Antules's case, my lord, is that the power of the court is not taken away. And I'm given to understand, my lord, that question is pending before a larger bench. In any event, my lord, that may be a little premature to be discussed in this proceeding today. Because we are looking at, now, my lord, your lordship may kindly look at what we have now placed for your lordship consideration, my lord, is section 17A has been considered, my lord, in Yashwant Sinha's case.
That's the beginning.
That's the beginning.
The first judgment on 17.
Exactly. We have put all that, my lord, so that it's all in one place. And then, my lord, there is another submission that I want to make. Yeah, my lord, there are two situations. One is absence of sanction. The other, my lord, is invalidity of sanction. Now, can the question of invalidity of sanction be taken up before the special court?
See, that is one point where sanction is accorded, invalidity of sanction or otherwise in normal circumstances. Now the issue is sanction is accorded by a constitutional authority. That cannot be taken there. Therefore, the validity of that sanction, whether it bears application of mind, it is needed or otherwise, is only by this court. That cannot, the court of session cannot sit and scrutinize what the governor has said, whether he has applied his mind, he has done that, he has done this. No. This court is.
That distinction that your lordships are putting to me between a sanction that is accorded by
You began the submission saying that this is governor's sanction, high functionary's sanction. It is not like a Tahsildar issuing sanction. The same thing applies here also.
Now, that submission was made, but not in the context of the fact as to what is the extent of judicial examination.
See, that is why
that purpose.
the extent of examination, if that is so, that we are not examining the order of a Tahsildar, but we are examining the order of the governor of the state sanctioning or approving whatever is to be done against the chief minister of the state, then it's not that the court will scrutinize whether governor has applied his mind or not. Constitutional court will do it.
I'm not saying the constitutional court cannot. I'm saying, is it
There's nothing that this court cannot.
Exactly.
Yes.
There's nothing that this court cannot. In
See,
fact,
anything before this court is maintainable.
Exactly.
Whether it is entertainable or
that is
not,
the
it
point,
discretion.
that is exactly what the Honorable Supreme Court also has said, the recent judgment in
Yes.
Godrej Sarali.
Yes.
Supreme Court has said, the question when a writ petition is filed is not as to whether writ is maintainable. The
Every
question
petition is maintainable,
every
whether it is entertainable or not,
Exactly, Manoj.
it is the discretion of the
Exactly.
court.
Now, in a situation of this kind, now just look at what the Honorable Supreme Court has said, my lord, in 2020. Please be kind enough to turn to page 607.
No, it can be decided during the course of trial is what is
Exactly.
said.
Yes. Now, if in
One
a
minute, validity in that judgment was qua the competent authority. Competent, whether the competent authority had accorded sanction or not, that can be decided there, no problem. Here, that is not the question of competent authority here. Here it is the question of sanction being accorded by the governor to granting approval. Even sanction is said in that, so I can say granting sanction for prosecuting the chief minister. That cannot be. That I don't agree.
but the proposition seems to be a little wider than what your lordships have put to me. That it is only the power or who is the sanctioning authority which can be got into at the time of trial and not otherwise. But not the
No,
proposition
validity, qua the competence. See, now it is the managing director of a particular organization who is the competent authority declared to grant sanction. Somebody else has granted. That can be debated before the concerned court at the time of trial at any stage of the trial. That's a different thing. Whether here application of mind is there for the purpose of grant of sanction or otherwise, qua these people, yes, is triable here. And merely because it is to be considered during the trial, it would not lock the hands of this court to consider it.
No, I don't think I'm going to canvass that proposition at all. 226 jurisdiction, my lord, is unlimited. It is only self-regulatory, self-discipline, etc., etc.
So
there,
do that.
but in the facts of a given case where
I will answer that because that is also submitted.
Okay.
I will answer that.
But that just for reference, my lord, we are given the judgment of His Lordship Justice Bopanna as it then was at page 607.
Yes.
I'm not sure whether this was showed to your lordships.
No, Justice Bopanna or the
Yes.
page.
But at page 607. Well, the relevant portion is at page 613. Well, may I trouble you yourselves to kindly see the facts at para number 2. It seems to lay down a slightly broader proposition than what your lordships put to me.
Yes.
Lord, please now be kind enough to turn.
Para 11.
Paragraph number 11.
Yes.
Further, the issue relating to the validity of the sanction for prosecution would have been considered only during trial, since essentially the conclusion reached by the High Court is with regard to the defective sanction, since according to the High Court, the procedure of providing opportunity for explanation
Yes.
was not followed,
Those things
which will
can
result in the sanction being defective.
No problem.
Next sentence, my lord. In that regard, the decision in Dinesh Kumar relied upon by the additional Solicitor General would be relevant, since it is held therein that there is a distinction between absence of sanction and the alleged invalidity on account of non-application of mind. The absence of sanction, no doubt, can be agitated at the threshold, but the invalidity of sanction is to be raised during the trial. In the instant case, admittedly there is sanction, though the accused seek to pick holes in the manner the sanction has been granted and to claim that the same is defective, which is a matter to be considered in the trial. So, my lord, on this,
we have not yet reached sanction. We are at approval threshold.
yes, my lord, but it doesn't really bear any difference.
No.
It doesn't
See,
bear
sanction is post investigation.
Yes, it is different stages.
No, the
It is
sanction
different
is post between 17 and 19. What happens is investigation.
Absolutely.
Abundant material to seek sanction to prosecute.
Absolutely.
Now there is prima facie material, needle of suspicion in 17A.
Yes, needless suspicion. No, I'm only saying, my lord, only for this purpose. If you can raise the correctness of a sanction under 19, even 17A is a matter that can be raised there. So, my lord, I would say, my lord, that this principle should be extended there also. That's a submission I'm making, my lord, because I believe, my lord, Dinesh Kumar also says the same thing.
Yes.
And then, my lord, your lordship may kindly look at the next proposition.
Yes.
Sanction is an administrative order, my lord.
That
I
is-
think it's
that
already
is-
been, my lord, I'm conscious that it has been told to your lordships. We are just giving your lordships all the material in order
And
to
these judgments are also
assist,
given.
in order to assist your
Yes,
lordships in
yes.
writing the judgment, my lord. That's all. Then, my lord, commission of inquiry, what is the scope? It's just a report, and my lord, the Supreme Court.
No, it is only recommended.
The Supreme Court says it is unfortunate that most of the reports don't see the light of day.
Anyway, but it's recommended.
Yes, my lord, absolutely. And then, my lord, kindly turn to the next one. Next page. Complaint need not be a detailed complaint. My lord, your lordships are aware of that proposition. It need not be an encyclopedia. But what am I going to say as a complainant? I don't have all the material.
No, in fact, in this case, it is detailed.
In this case, we have written 5-6 pages, my lord, and single line spacing.
Single line spacing. Adnan nodliಲ್ವಾ? I did not look into that. Yes.
ಇಲ್ಲ, the complaint is in single line spacing. So much of material has been, so many
No,
facts.
it is in detail.
It is in detail. Therefore, my lord, we have given your lordship the 3 number 30 and
It is in
31.
detail. The complainant has appeared before the governor. The governor has heard him.
Not as my lord,
R3.
our
R3.
yes. And then, my lord, on this question of natural justice, I just want to point out, your lordships, how natural justice, my lord, is not some straitjacket formula. Kindly see, my lord, serial number 26. Ashok Kumar Sonkar's case.
All of them follow unruly horse.
Yes, unruly.
1977,
Unruly horse.
Ramji.
Yes.
Yes.
And it should not be a futile exercise. Now, my lord, let us, the complaint that I have filed and the complaint filed by Abraham are identically worded. Now, if you're given notice in one, what does it matter? And you have taken a decision in respect of one complaint which is identically worded, so far as I am concerned. What does it matter if my complaint is also referred to in the approval order? How does it affect the petitioner? Therefore, my lord, natural justice should always be coupled with prejudice. There is nothing like natural justice standing alone as a point without showing prejudice. And if prejudice is not shown, then, my lord, the plea that there is a technical breach of the principles of natural justice, even if one is to apply that, and I would maintain, my lord, that at the stage of 17A, there is no requirement. Contrast the language to 19. 19 requires
So
that.
19
Requires that.
Statutory
17A is the same statute the lawmakers provide for hearing. In another provision, they don't. What is the necessary influence? That insofar as 17A is concerned, it is excluded. So, my lord, without prejudice to that submission that there is no requirement, and all this notice that was sent by the governor was only by way of, I would say, my lord, abundant caution. It is only, my lord, to satisfy, maybe, my lord, some that unruly horse. Even
All
if it's.
right.
So, my lord, if that is so, my lord, the fact that the complaint filed by respondent number 4 was not supplied to the petitioner does not in any manner vitiate the order. And then, my lord, the meaning of the word, my lord, previous approval, we have set out 32 to 34, my lord. May not be so relevant, but for the because the words used is that. Anything else? My lord, I think, my lord, with this I have shown to your lordships all the facts and the law which I thought was relevant.
Thank
I'm
you,
grateful
sir.
to your lordships.
Thank you. Sir.
Anything else?
Wait, sir.
My lord, there's one
You-
small
ಮತ್ತೆ ಸ್ಟೇಟ್ ಶೇಕ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ಬೇಡಿ.
My lord, one small addition I want to make. My lord, there is an interesting book on Kerron frauds. I want to show to your lordships one passage in that.
Fraud and
Really?
mistake.
No, I'm on fraud.
ಅಲ್ಲ book.
ಈ book sir. Book sir. It is a both, my lord. It's a well
Yes.
recognized. Kindly see the first page, my lord.
First page.
Yes.
Page 1.
Page 1. It says chapter 1 under the heading fraud. My lord, I have a slightly older edition. Maybe I don't know which edition your lordships have, but if your lordships. Fraud and mistake. Is that how it begins?
1 minute, sir.
Fraud and mistake as grounds of relief are alike founded on ignorance. Is that how it begins, my lord?
Yes.
Yes. There can be no mistake where there is no ignorance. There can be no fraud where there is no mistake. It is not easy. This is the passage I want to rely upon, my lord. It is not easy to give a definition of what constitutes fraud in the extensive signification in which that term is understood by civil courts of justice. Courts have always avoided hampering themselves by defining or laying down as a general proposition what shall be held to constitute fraud. fraud is infinite in variety. The fertility of man's invention in devising new schemes of fraud is so great that the courts have always declined to define it or to define undue influence, which is one of its many varieties, reserving to themselves the liberty to deal with it under whatever form it may present itself.
No, fraud has many hues and forms.
Hues and forms.
So
And then, of course, my lord,
it-
all that.
every
No, my lord, I
every
thought-
case that comes up has a different hue.
And that's why, my lord, the author says, fraud is infinite in variety, and the fertility of man's invention in devising new schemes of fraud is so great, the courts have always declined to define it or to define undue influence, which is one of its many varieties, reserving to themselves the liberty to deal with it under whatever form it may
Yes.
present itself.
We'll look at it.
Therefore, my lord, fraud, my lord, is never committed in daylight. It
It's
is
like- It's like conspiracy.
always done under cover. And it is therefore, my lord, the responsibility of the courts to say, how do I read between the lines of an action to find out if there is fraud? It is a very difficult exercise. And there's one authority, my lord, that I want to show. With that, my lord, I shall not detain your lordships, my lord, only to say that the higher the authority, my lord, 2004,
Higher the responsibility.
2000, no, and limited is the role of a court.
That is true. Yes, correct. That
Well, yes.
current SG has shown.
2004, I don't know whether this was shown to your lordships, Bikash Chatterjee's case.
I think so.
2004, 7 SCC
Sir, put it on
634. Well,
I'll see if it is repeated. we will
repeat
examine.
it, better.
No
Repeat,
problem. No,
repeat it and stop. It.
you can read, sir.
Well, kindly turn to paragraph number
This
10.
was shown. Yes.
It was shown to your
Yes.
lordships by para 10.
President of India's, I think this.
Yes. Para 10. In the case of Maruram versus Union of India,
Pardon rejection. Yes.
I will not.
Yes. Yes.
If it's been shown, my lord. Great.
No.
You're empty handed. ನೀವು ವಾಲ್ಯೂಮ್ ಕೊಡಿ.
ನಾವು ವಾಲ್ಯೂಮ್ ಕೊಡಲ್ಲ, ಅವ್ರ ವಾಲ್ಯೂಮ್ ರಿಲೈ ಮಾಡ್ತೀವಿ. ಒಳ್ಳೆ ಟೈಮ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀವಿ.
ಟೈಮ್ ಕೊಡಿ ನಾ ಅದು ಮಾತ್ರ ಕೇಳಬೇಡಿ. Finish your submission, sir.
Kindly have it on Monday, Manoj.
Why?
After that,
Next Monday.
yes, Manoj.
Why?
When Friday is a holiday, Manoj, I need to go in detail. Manoj, I'll make a synopsis and place it before your lordship.
Hello, what are you? The Advocate General state is.
No, Manoj, because submissions were made with regard to aid and advice and the opinion of the Advocate General and few aspects. As respondent,
Submissions were made about the fairness of the Advocate General.
no, that is one aspect, Manoj. It's a backhanded compliment. Therefore, I need to place certain aspects, Manoj, on
ಅದಕ್ಕೆ
163.
ಒಂದು ವಾರ ಬೇಕಾ?
Manoj, in fact, and again, Manoj, on 4th again.
So when is senior counsel completing now? Now that all the respondents have completed, you are neutral. That's why I'm saying all the respondents have completed. When is Singhvi sir completing?
Sir,
Sir,
I will, Malas, I will go after the AG. The reason is, Malas, that
Not
there
after
is.
me, Manoj, next. month I
after the submissions of the AG,
submission of-
Yes, yes.
I will go after the AG. That
I dare not, Malas, I dare not. Especially if I have to visit Bangalore. No,
Yes.
Malas, I will move after the AG. The reason was there is a whole cabinet note, there is a whole AG opinion that he alone
Yes.
can deal with. Malas. So let him deal
Yes,
with it
sir.
at some length. Malas. My other problem is, Malas, I have a intention to make a comprehensive thing for 4 or 5 council who have argued against Malas. So I'll put it
Yes,
all
sir.
together. So we'll fix up the date on the date after Mr. AG finishes.
No,
Malas. Then the dates will be clear.
will you finish it on Thursday? Monday I will take.
Your Lordship may have it because I need that weekend, Manoj. Your Lordship, Monday.
Because I will not be able to come on Monday.
Yes, so we'll, as we did the other day, we'll start at 10:30 and finish it off on that day. Whenever you say, not
No,
too
well, it's-
fast,
but-
sir.
My learned friend, I believe, is asking for Monday. So I'll do it shortly after that.
The request is this, Manoj. At least I'll have the weekend to just prepare. That's the only thing. Just one day, Manoj.
No,
6th or
Don't, do this during festival. ಮುಂಚೆನೆ ಮುಗಿಸ್ಬಿಡಿ.
No, the only thing is I'll just take a couple of hours before
Couple of hours.
before the petition commences, Manoj. So therefore, your Lordship may kindly fix a date, Manoj, after 9th or any other day.
That's true. We'll take it on 5th, ನಿಮ್ದು. you finish on 5th, whatever you say, then senior counsel, I'll take it on Monday at 10:30.
Well, I can't do it on Monday in any case. Your Lordship may give him some time. I'll do it little later after Monday. I was thinking of longer after him, but since Your Lordship is asking him to do it on either 9th or 5th, I'll do it after the 9th. I've checked up my dates. I'm in some difficulty.
Tentatively, what date, sir?
Well, it's frankly, I would like the working Saturday, which Your Lordship has advertised in the calendar. I know it's too far away. But I could do the whole day and finish it. That's my first request. I'm in Your Lordship's hands. It will suit everybody. We'll all spend the whole day and finish it off. And I'll put it together. That's on Your Lordship's calendar, Wallace. That's what I thought I would do.
Let me see.
And that's why my learned friend can argue on 9th, Wallace.
9th.
I know, Wallace. I'm sorry that it's a little difficult before that. That's why I was saying.
If your Lordship, that means I think,
No, this issue shouldn't stretch too
then
long.
I'll do it on 9th and I'll complete it. 2:30.
That's all.
9th and 21st, Your Lordship may keep it, Wallace. We'll finish both of us. Lordship will take it.
21st is too far, sir. This side of the, so we have vacations from 1st of October. 2nd of October, rather.
No, of course. There's no question of taking it beyond vacation. I will finish it in that one day.
No, not beyond vacation, but should also finish. I should write. Volumes after volumes are given. And AG is now saying he'll also give volumes.
No, I'll rely upon the volumes, I said.
And raise your volume. Yes.
That's just so.
Can it be on 13th, sir?
No, then, Wallace, if it has to be, it'll be on 12th is better
12th,
than 13th.
yes.
But Wallace, can I ask your Lordship to have a review petition on 9th after you finish it, Wallace?
Review petition?
Reconsider.
From my
the
side,
date on the
Reconsider,
date.
yes, sir.
Reconsider.
Anyway, at the moment, your Lordship put it on 9th and 12th. But Wallace, in case there is some difficulty, your Lordship may keep in mind 21st. Otherwise, 9th and 12th for the time being. 9th for him, 12th for me.
Today's for 2nd.
2:30, then we'll.
You need a week.
Anyway, I'll do it on 12th. Wallace. My slot, let it be 12th. Whatever your Lordship adjust with the
Because
AG.
we have stalled the proceedings
Understand.
there. It's not,
No, 9th,
correct.
2:30, I'll complete minutes. I'll not take much time.
yes. Then we'll take it on 9th at 2:30. No further adjournment there.
No, I'm seeking for 2:30 itself. I'll complete it.
Yes, but
And 12th, your Lordship will review it that day. It may be earlier even. I mean, before 2:30, I get enough time to cover. It may be pre-lunch little bit
Sorry,
and then
sir,
covering the afternoon also.
your voice is not.
Well, on 12th,
Ah.
on 12th, your
Ah.
Lordship may want to start a little before lunch also, so I get more time.
No, whatever time you say, we will.
Yes. So on 12th, well, I'll do it. After you finish on 9th,
Then 12th, if
I'll
you're
do it.
present, we'll finish it off.
Yes.
Yes. Then
Yes,
we'll keep
yes.
9th for the
I'll
AG
complete.
submission and 12th, we'll finish it on 12th. Yes.
Obliged. Deeply obliged.
Yes. Heard so and so, Marty. The learned Advocate General seeks a week's time to make his submissions. List the matter on 9th at 2:30 p.m. Other Navath record mar 12th. Intermodal subsystem. Granted on 19/8.
Grateful to my Lord.
Yes. For the time.
Deeply obliged, brothers.
Yes. Hey, one matter there.
Grateful.
Yes. In the lighter way, sir, don't wind anything. Whatever. The monotony should be broken.
Milord?
Monotony
Of course,
big case should be broken.
of course. That is how, Milord, Julius Caesar also came.
Yet to Brutus. Yes.
Yes, Milord. Plutus was an honorable man.
You too, Brutus. That's what I said.
Your brother had his eyebrow.
That's what I said. You too, Brutus. There's one matter which is
Sorry.
moved at 2:30.
Grateful.
ಅಲ್ಲ ಅವ್ರೇನು ಹೇಳಿ ಆಯ್ತು ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಬಂದಿದೆ ಬಿಡಿ ಆಮೇಲೆ ಎಲ್ಲರೂ ಮುಗಿಲಿ ಬಿಕಾಸ್ ಯು ವಿಲ್ ಮೇಕ್ ಎ ಶೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ ದೆನ್ ಬೇರೆಯವ್ರದೆಲ್ಲ ಮುಗಿಲಿ Yes, sir.
to thank you at the outside for allowing public.
No problem, sir. Yes. Yes, Ravi Shankar. Hey, ivattalla. Reserve your arguments on 9th or 12th. And AG ಅವರೇ,
Please,
those dates ಮುಗಿಸ್ಬಿಡ್ಬೇಕು.
done.
No
We'll do
more
it,
adjournment grant.
please.
The offense is like 465, 468, 471.
230 ಯಾಕೆ move ಮಾಡಿ?
ಅದೇ like the petitioners are
Yes,
the
police
second.
station.
ಹೌದು ಹೈದರಾಳಿ.
Nothing like that.
No. It has been transferred from Whitefield to this police station. Perhaps not, it has been happened in the Whitefield police station.
2.5 months ago, the FIR came to be transferred to Badrali police.
No.
ಈಗ ಏನ್-
If they had